All right. John Rodriguez signing.
Mr. Hubert.
Yes.
Thank you very much for adding additional silencing equipment. Since the last two hearings, the clicking was still audible. I appreciate that. Okay. Well, we are here on, whoops, we're going to wait for your court reporter. No, this is not, it's not, don't have it all there.
Your Honor.
Mr. Minnick, is that you?
It's Gary Taylor from the...
I am sorry, you are not getting them. You may be seated. Thank you, sir. I apologize, Mr. Minnick. I was looking at the screen. The voice seemed to be very familiar. Obviously, does not appear on the iPhone. I can't buy it. Yeah, I read all the stuff. I had it on my apologies for the delay. We had a number of foreclosure matters that we needed to take up before the court was able to address you. I've also had a number of inquiries from the media that have delayed our starting. So at this point, or I should say non-parties. Let's have, Madam Court Reporter, how are you doing? Are you sure? You need a couple minutes? You want to stretch your fingers? We're good. Let's have a recognition and an identification for the record of who the parties are.
Keith Mitnick and John Bill for Sonata Gonzalez.
Is that the gentleman that's seated next to you?
Good morning.
All right. And you are, sir?
Judge, good morning. Jonathan Kaysen, K-A-S-E-N, on behalf of Casey Anthony on the civil matter.
All right. The matter that has been noticed for today is the defendant's motion to dismiss. Is that correct?
Judge, I believe, as I understand it, I think there's actually three motions. One from the defense, and I believe two from the
And we thought we were going to be able to do this in half an hour?
Well, actually, Judge, may I make a suggestion?
Sure. I think there's some that are set for, what, Thursday?
There are some Thursday.
Yeah.
There is a motion to dismiss pending that they filed, but it's kind of mooted because we also have a motion to amend the complaint to add newly discovered evidence as well as it adds punitive damages. It would seem to make sense.
Are we planning?
If we can hear our motion for the proffer on punitive damages.
That's what I was going to go ahead and ask. Are you prepared to make a proffer?
We are.
On the punitive damages issue?
We are, and because we will be amending the complaint anyhow to add the newly discovered evidence, and it would make sense to amend it once, presuming that we sufficiently proffer to the court on the punitives, and then whatever they feel they need to file in response to that complaint, then we can come back and have it heard at one time.
Let me also ask if the basis for your contention that the motion to dismiss is moot is based on the fact that the motion to dismiss is grounded on the failure to show damages, and that by the proffer, as well as by the amended complaint, that you might be attempting to cure that issue?
Well,
Or does it go beyond that?
It goes beyond. Well, number one, it's not, their motion to dismiss wasn't timely. They have to file it before. Now, I'm not bringing it up because if we amend the complaint, that cures that problem. But they have to file the motion to dismiss before they answer, and they answered like 3 months before the motion to dismiss. So it's not timely. Doesn't
I'm
matter.
going to the merits.
But when we get to the merits of it, the amendment
But you see,
actually,
that procedure would be simple to cure. The whole idea is I want to go ahead and try and see if we can focus on the issue and
yes,
dispose of it.
and I would like, we can get to the meat of the issues with the amended complaint and have permission to file the amended complaint, then they can attack it in any way they seem fit, and we can have a hearing on the merits at that time on those issues. That would seem to make sense.
Counsel.
Well, Judge, my only objection and my only concern is the following. What we're in effect doing is just delaying the inevitable. Our position is going to be that the motion to dismiss will be the same whether it was filed several months ago or whether it will be filed in a couple of weeks after Mr. Mitnick files his amended complaint. I think it's more than just a damages issue. They failed to state a cause of action, number one, in our estimation. And second, they've never established that the individual in question, his client, Mr. Morgan's client, is the individual who was allegedly disparaged or defamed in the instant matter.
But you know that basically if I were to go ahead and look at the motion to dismiss, I've got to look at it as even if every single allegation were true.
Correct.
Okay? And then look towards the four corners of the document to determine whether or not that document, as well as any attachments or exhibits, would provide a basis for the cause of action. A motion to dismiss does not get into the truthfulness or the veracity or weighing any evidence at all. Am I correct in that?
Well, I think partially and partially not. It's our contention, Judge, that you can't simply file a matter for a defamation or any cause of action until you can explicitly establish that the individual in question was either A, disparaged in some way, or B, that it's the person that has some connection to the case. And I've mentioned in a number of other previous pleadings, Judge, that the name is a common name. I'm from South Florida. You know, names that end in Z are very common. But as
Do
you
not lecture Jose Rodriguez about South Florida.
well, I don't know where you were from, Judge. I'm
I
from Miami.
graduated from Miami Senior High.
Okay, I graduated from Palmetto, so we were rivals in high school.
Never would have. I'm too old.
Well, our school, anyways, Your Honor. But my point is that they've never established that the individual in question is the same person that was allegedly disparaged.
But you know that all they have to do is make an allegation. And that all they have to do is make an allegation. And I believe that there may be ample statements that when made, and because they may have to be taken to be true, it may get past that hurdle, that threshold.
It may, but I think it's been very speculative up to this point, Judge, to say that it would get past any hurdle.
In any event, Judge, can I intercede? I think the counsel's confidence, I'm sorry?
Go ahead.
I think counsel's confidence in his motion to dismiss is woefully misplaced when we get to it. When we get to it, we'll see.
Let's get to it today. Let's not argue about tomorrow.
Hey, Judge, I would just ask that Mr. Mitnick cannot direct his comments to me, but to Your Honor. I don't need to...
I'll be glad to, Judge. Because of some of the personal attacks.
Suggestion.
Sir, yes, sir.
If that continues, or that's the last time those remarks will go. If you need me to remind the advocate that the advocate addressed the court, approach the bench and ask me to do that.
Yes, sir.
Okay? The next time, and don't forget, when I'm addressing you, you probably will.
Yes, Your Honor, I'm sorry.
We're going to go ahead and do this by the book. And what we're going to go ahead and do is if we are going to have an untoward and unprofessional, not that this is unprofessional, but any other sniping, I will cancel the hearing and let you set it for another day when we can come and everybody can go ahead So I need your best. Let's have your best at this time, Mr. Nick.
Yes, sir.
As far as...
And I will go to the argument, and I will save for the end some questions about counsel, and I will direct those questions to you. But I would rather deal with the merits first, because that's far more important. So on the